Getting set up. Some of you know me, some of you don't. I'm Peter Adler from Massachusetts. I teach in the law department at University of Massachusetts. I'm really pleased to be at the symposium, as always. The origin of this talk is, and how I got involved in activism, I thought I would start there, is that when my son was born in 1983, and we were at a Harvard hospital, and a physician came into the room and asked, have you decided whether to have your son circumcised yet or not? And this was a very odd question because my wife and I had never even considered it. And then my wife's a physician, so I looked to her to give some input, but she'd given birth the day before on medications and was tired and nursing, and in retrospect she was, in my opinion, legally incapacitated. So then the doctor launched into what Bob Van Houw calls the talk, where the doctor said at the time, based on the AAP's position then in effect, that circumcision reduced the risk of urinary tract infections, penile cancer, and some sexually transmitted diseases. So it had potential medical benefits. But then interestingly, he said, but that's not a medical justification for it. And he said because urinary tract infections can be treated by antibiotics, penile cancer is rare and occurs in old age, and circumcision cannot responsibly be viewed as protecting against sexually transmitted diseases. So then I was thinking, well, all right, then the answer is no. But then he started saying, well, would you like to have your son circumcised for religious reasons? I said, well, what do you mean? I'm not religious. And then he said, well, some people have their sons circumcised for religious reasons. I was thinking, well, I don't care about religious reasons. What's that got to do with my son? So then he said, well, some people, circumcise their son for cultural reasons. I'm thinking, well, that sounds stupid. I mean, this is a medical thing. You're a doctor. Why would we do that? But this one that really got my attention was he said, well, some people choose circumcision for personal reasons. And I said, what do you mean? And then he said, well, some parents, when the father's circumcised, they want the son to look like them. And I was thinking, well, that can't be true as a legal matter. And I went off and I started thinking about law school. And I remember thinking, well, he needs my consent, because without my consent, it's a battery. And, but I don't believe I have that right to make a decision like this for my child for non-medical reasons. And this was all in a matter of, minutes. And, sometimes you win, sometimes you lose. This one, I sort of figured it out. And I had an intuitive sense that, the duty of the physician and of me was to the child based on medical reasons, not these and any other reasons. So, it led over many years to my questioning circumcision and, what are the physician's duties to children and boys. So that leads to the question of what are the legal claims that physicians have against physicians who, that lawyers have against physicians who circumcise or offer to circumcise. So it seems there are two types. There's negligently performed circumcision, it was performed badly, and then there's unnecessary surgery that should not have been performed at all. So then within that, what groups do we have? So with respect to female genital cutting, when Congress passed that statute in 1996, they said in findings that female genital cutting, except for therapeutic purposes, violates girls' statutory and constitutional rights. In other words, it was already illegal before they made it a federal crime. So then the question is, how does it apply to boys? Well, the same way, building on what Brian Earp talked about yesterday. Male genital cutting violates the child abuse statutes. Brigman said that, wrote that in 1985. There have been numerous articles by Stephen and others saying that circumcision violates boys' constitutional rights. So the right to equal protection under the law, as was discussed yesterday, Shaylee de Bond wrote in 1999. Then in the German case, the right to bodily integrity and self-determination, a constitutional right under the US Constitution. And then we've had this great decision in the UK where two Muslim boys, the father wanted them circumcised, and the court held that they might not choose to be Muslim, to follow the religion. They might not want to be circumcised, and let them decide for themselves. So those are all really good claims, but here my thinking was they all present problems of proof. So let me explain. You know, in a civil action, one of the parties has the burden of proof in civil cases by the preponderance of the evidence. And so that's a difficult burden to meet. It means you have to prove that something is more likely than not. So if you want to bring these constitutional claims, then you'd have to prove that boys have these constitutional rights that we just talked about. You'd have to prove that the circumcision was performed for non-medical reasons, as it was in Cologne, Germany. Then you'd have to prove that the boys' rights supersede their parents' rights. And I'm thinking this won't resonate with physicians. They're not lawyers. So I completely agree that the Cologne decision should apply in the U.S. under U.S. and international law. All I'm saying is it has, you know, problems of proof. So the child abuse claims, it's the same thing. You know, we want to claim it's child abuse. We all know it is. But then we have to prove it's not medicine. Then the doctors show up and say, well, it has all these medical benefits. You get in a big dispute. And then you'd also have to prove that physicians don't have the right to perform it even if parents request it. So then that led me to think, well, what about a claim for breach of fiduciary duty? What is the fiduciary duty of physicians to boys? So the courts look at it this way, that physicians have superior knowledge of medicine. And in fact, Dr. Freeman of the Task Force on Circumcision wrote an article saying we claim superiority in the medical realm. Parents know little or nothing about it. And then, you know, the younger a boy is, well, they're below the age of consent, whatever age they are. The younger they are, the less they know. And if they're infants, they're unable to reason and speak, so they're especially vulnerable. And so what courts have said is that physicians are in a dominant position of complete control where they could easily take unfair advantage of, they don't say parents, they say patients, but in this case it would be of boys and their parents acting on behalf of the children. And so the courts have often stated, and this is, you know, black letter law, that the physician-patient relationship is based on trust, that physicians have a strict fiduciary duty of loyalty to their patients. Physicians cannot violate the patient's confidence and trust in the slightest way. And this is the highest duty in the law. So it's comparable, for example, if you gave $1 million to an investment broker and you said, please invest it for me, you know, the investor would need to act as you would want him to act based on your directions and not take advantage of you and take your money. You know, what are the strategic advantages of bringing a claim of breach of fiduciary duty as opposed to these other claims? Well, in most jurisdictions, in most states, they say it's not a malpractice claim. Illinois is an exception. But if it's not a malpractice claim, I think David Llewellyn could tell us it's much more straightforward, fewer requirements. So then, if you have a breach of fiduciary duty claim, the focus is on the physician's medical duties to boys. And importantly, it takes the focus away from the non-medical preferences and claims of parents, because the title suggests it's fiduciary duty to the child. Oh, this is really important. It reverses the burden of proof. So once a plaintiff claims that a physician took unfair advantage of him or a boy, whether he's a patient or not, or parents, then there's a presumption that the physician or medical provider in the hospital took unfair advantage of the defendant, of the plaintiff, and then the defendant has to prove that there was no breach. So then the burden is on the defendants to prove that circumcision is medicine and to prove various other things. And that can affect the outcome of the suit. And then in addition, some courts say that the defendants can be liable for constructive or imputed fraud because it's so important not to take advantage of these vulnerable people like young children. And if you do, there's a possibility of punitive damages and the statute of limitations starts to run upon discovery. So what I wanted to look at, particularly for this talk, was what are the fiduciary duties? You know, they must be trustworthy. Well, what does that mean? So the elements of the breach of fiduciary duty are the existence of a fiduciary duty, and that's a given. It's universally recognized that physicians have a fiduciary duty to the patients, and especially the more vulnerable the patient is. Then the question is, was there a breach of fiduciary duty? And then you have to show damage proximately caused by the breach. But that's a given. I was very pleased to find more cases than I'd found previously that said unnecessary surgery is injurious and causes harm to the patient. Even if a surgery is executed flawlessly, if it were unnecessary, it in and of itself constitutes harm. A person has unnecessarily gone under the knife and experienced pain and suffering. And I found several cases like that. One even said, you know, an unnecessary injection causes pain and suffering is unnecessary. So what are these fiduciary duties? As I said, you can't breach trust or confidence in any way. So under the AMA rules, a physician is required to give prudent professional advice as to the optimal medical course of action. Physicians must act in the best interests of their patients, keeping their interests paramount. They must respect patients' legal rights, including the right to self-determination. They must uphold the ethical norms of their profession, including fidelity to patients. So that's another ethical rule. They must be loyal, honest, fair, not use undue influence, and act in the utmost good faith. And they must fully disclose all facts that might affect the patient's decision. So then the question is circumcision a breach of these duties? And I think, you know, you all know the answer is yes, but I'll just run through it. So as to requirement number one, physicians must give prudent professional advice as to the optimal medical course of action. Well, the boys are healthy, and physicians ordinarily operate on children only after the diagnosis of an injury or a defect, and in fact that's the definition of surgery, and even then as a last resort. So unnecessary surgery harms all boys and men with little or no prospect of benefiting them in childhood. And even in adulthood, there's little prospect of benefiting them, and there are more effective and safer ways to achieve the benefits. So I think we would all agree the only prudent thing for a physician to recommend is do not operate on healthy children. There's no medical reason to do so. Physicians must act in the best interests of patients and respect their ethical and legal rights. That prohibits harming healthy boys. The legal and ethical rights seem to parallel each other. So there's a right to bodily integrity and the ethical requirement of not harming patients. There's the requirement of benefiting patients, the legal requirement of alleviating suffering, and the ethical rule of beneficence. Then there's a legal and ethical requirement to respect the autonomy and self-determination of the patient, which is a cardinal rule. And then I think very importantly, and this dates back to my thinking from when the doctor spoke to me, that it prohibits male genital cutting when it can be inferred that males would not choose it for themselves if given the choice. You know, babies don't want to be circumcised. Young men, when they learn what happened to them, they're angry to have been circumcised. Older boys are unhappy about what was taken from them. And then, men can be seriously aggrieved, and men rarely choose it for themselves. So it violates the fiduciary duty to boys and men to do, for physicians to do to them what they would not choose for themselves. But it also prohibits taking orders from parents based on the parents' own best interest. It's the interest of the patients that matter. Physicians must be loyal, honest, fair, act in good faith, and obtain fully informed parental assent to all procedures they're allowed to perform. But physicians are not honest and fair when they solicit circumcision. They use undue influence, high-pressure sales pitches in hospitals, such as occurred to me. They don't use the right standard. They want us to weigh pros and cons without talking about the ethics. There's very little discussion of the ethics or legality. They exaggerate the benefits, understate or don't disclose the disadvantages. They give no value to the foreskin. Falsely claim that the benefits are greater than the risks. And they make misrepresentations of law. It's just not true that parents have the right to elect male circumcision for non-medical reasons, and it's not true that physicians are allowed to take orders from parents to perform unnecessary surgery. It violates the fiduciary duty to the child. Finally, physicians also are taking unfair advantage of patients and enriching themselves, because the boys are healthy, they're no longer patients. They should be discharged. They're not candidates for surgery. Physicians don't disclose that they have financial, cultural, personal, and religious biases of their own. And basically, they enrich themselves financially by promoting their own religion, religious beliefs, cultural biases, and personal preferences by taking something of value from boys. This is a claim that could be added to any circumcision claim, including perhaps a negligence claim. It's another claim that could be added, if you will, to the arsenal of tools that lawyers have. It has very broad reach because any breach of trust is a violation. So if you can, the question would be, well, can you trust your physician? If the answer is no as to anything, well, that's a breach of fiduciary duty. So it includes every ethical and every legal violation. So all of the elements are present: fiduciary duty, multiple breaches, and injury caused as all circumcised boys and men are harmed. It just depends to what extent. And physicians are benefiting themselves by taking something of value from boys. To summarize again the advantages, the breach of fiduciary claim focuses on the physician's duty of loyalty to the patients. It appears to me it takes parents' demands completely out of the equation. It doesn't matter what the parents want. Medicine is all that counts, making a good professional recommendation. The burden of proof now falls on the defendant to prove no breach, and they have to prove that unnecessary surgery is permitted, and they're not going to be able to do that. Seems likely that this cause of action begins upon discovery, and then would be 6 years after that. And there's a possibility of punitive damages if a court finds malfeasance, which I think could be found.